Okay, just to let everybody know, we're going to be about running behind about 10 minutes.
docket and is at the main jail.
I got him.
All right, they would like Mr. Cooper's case called first, if that's possible.
Okay, all right, good morning, everybody. My name is Judge Kim Teresa Malika. You're in first appearance court. Today you will be informed of the charges and we're going to determine if there's probable cause. Today is not your trial day. Do not talk about the facts of your case. Everything's being recorded. You have the right to remain silent. You also have a right to an attorney. We have Mr. Romero today at the main jail? Okay, we have Mr. Romero. Good morning.
Yes.
Good morning. We have Mr.
Good morning,
Romero
Judge.
at the main jail, and we have Mr. Reedy, who's here in the courtroom with me. If you have a private attorney, when you step up to the podium, please let me know. The jail is asking for a case to be called out of turn. Jeremy Cooper.
Mr. Cooper is approaching, Judge.
Okay. Good morning, Mr. Cooper. You're being charged with one count of false ID given to a Leo. There's no bond attached to that. Then we have resisting an officer without violence. Bond is set, it looks like $100. Count 3 and 4 is a warrant for felony pretrial, which there are no bonds attached to that. And counts 5 and 6 are capious misdemeanors, which are $500 bonds. So total, we have bond of $1,100. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. Anybody want to be heard with regard to, oh wait, we already did find probable cause yesterday. Yeah, I just looked at my notes from yesterday. So today we just have to talk about bond, which is $1,100. Anybody want to be heard?
Judge, considering he has a no bond hold on his counts 3 and 4, Judge, nothing to add at this time.
Okay, bonds will remain as they are. Thank you very much. Okay, first person is going to be Harvey Quinney Barnes, please. Yesterday it was a medical reset.
I think he's North Broward, Judge.
Okay,
Mr. Reedy, that's the guy you spoke to earlier and you sent him back? Possibly for the PM because it was an extradition?
it says medical reset from yesterday, but he needs to be magistrated on the out-of-state holds for the felony.
Okay, we'll get him down for you, Your
Let
Honor.
me just call Craig real fast. Can you see me?
Yes.
Okay. Hopefully it'll reset. I can see Paul Ryan, Conti, main jail. Okay, maybe it'll reset. All right, so is Mr. Barnes there, or?
We're gonna call him down, Judge. We'll let you know when he gets here.
Okay, they have to reset it because I can't see you.
Okay.
You can see me, okay?
All right.
So we'll recall. Let us know when he comes. Thank you. Okay, next one is Jamahn, Jamahn Arnold.
He's also North Broward, Judge.
Okay, then we'll recall him as well. Huh? Shanquita, Shakender, there it goes, he's resetting it. Cherry. Okay, we have North Broward back. All right, so let's recall these two. Let's see if we have Jamahn Arnold.
They're bringing him back right now, Judge.
Okay. When you say bringing him back, wasn't that the...
There was a little bit of a miscommunication. It was my fault. I was telling Mr. Arnold that he'll probably be in extradition court either this afternoon or Thursday afternoon, and they took that to mean that he didn't need to be here this morning. So that was my fault for not being clear enough with the
No,
deputies.
that's fine. What about Harvey? I think he is. Willie will tell you. Arnold is not on the docket for today, so he'll be on for Thursday. I believe Barnes is on. I'm not sure. Okay, what about Harvey Barnes? Is there a Harvey Barnes?
Yeah, I think they're getting him as well, Judge.
Okay.
Yes.
All right,
He'll be here shortly.
just let us know. Thank you. Okay, Shanquita Cherry, please.
It's a medical reset.
Sylvia Martinez Mitchell, and then after that, we have Alicia McNerney.
Miss Mitchell is in Paul Ryan, Your Honor.
Okay, thank you. Hello, ma'am, how are you?
Fine, thank you. Good morning.
Good morning. Are you Sylvia Martinez Mitchell?
I am.
Okay, you have two capious misdemeanors. One of them you're ROR'd on. The other one you have, it's a driving while license is suspended. There's a $2,000 bond that has been set.
Yes, ma'am.
All right.
Your Honor, I spoke with Miss Mitchell. I didn't speak with Miss Mitchell's son. I did leave him a message. Miss Mitchell's indicated to me that she believes that her family will be able to post her bond. So I'd ask you, the court, to leave the bond where it is.
Okay, thank you.
And I'll keep trying to reach your son, Miss Mitchell.
Thank you, sir.
Okay, Elisa McNerney.
I think she's a medical loan, if I'm not mistaken.
Okay, do we have an Alicia McNerney? I have Judge Pohl, who found probable cause yesterday.
Your Honor, Ms. McInerney is still a medical reset.
Okay, no problem. Natasha Stewart. Natasha Stewart, please. North Broward, is anybody there? What's going on at North Broward today? All right, I don't know, but let's recall North Broward. Rhonda Marie Williams.
Ms. Williams is present, Judge at Maine. She is approaching.
Okay, thank you, Mr. Romero.
Yes, sir.
Okay, are you Rhonda Marie Williams, ma'am?
Yes.
Okay, ma'am, you're charged with count 1, 2, and 3, and 4 are aggravated assault with a deadly weapon without intent to kill. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. Ma'am, I am going to tell you, I am going to order at the outset that there's no victim contact, direct or indirect, with the alleged victims in the case who have the initials of LH and KL. Direct or indirect, ma'am, means no in person, no calling, no texting, no social media, no contact even through third parties. You understand, ma'am?
Yes.
Okay, and their initials are LH and KL.
Your Honor,
Yes.
I think there are two more on the second page.
Okay, I didn't see it. Can you tell me?
BLS and BS.
Okay. There's also, ma'am, 2 more, so there's 4 total victims, BLS and BS?
Yes, ma'am.
Okay, so you have LH, KL, BLS, and BS. No contact, direct or indirect, ma'am. Okay, state?
Your Honor, based on the allegations, I'm requesting a $5,000 bond per count.
Okay, defense?
Judge, at this time in speaking with Ms. Williams, she is 38 years old. She's been living in our community her whole entire life. At this time, she is employed. She actually works 2 jobs. She works at Park Lakes Elementary. She's a campus monitor. She just got that employment, Judge. And then her second job is working for Hard Rock and Security. She's been doing that for the past 4 years. That job is part-time. Judge, she is a single mother raising her 3 children. She lives in North Lauderdale. I believe this is her first arrest ever, Judge, first contact with the criminal justice system. She is a registered voter in Broward County. Judge, considering basically her lack of any sort of criminal priors, her strong ties to the community, her financial resources, Judge, being she is a single mother, we'd be asking you to consider a $1,000 bond on counts 1, 2, 3, and 4. We believe that's reasonable under the circumstances, and Judge, she is presumed innocent at this time, and that's why we believe a $4,000 bond is reasonable in this situation, Judge.
Okay, this is what the court's gonna do. $2,500 bond on count 1, 1,000 on 2, 1,000 on 3, 1,000 on 4, and GPS open schedule. Ma'am, you're to have no contact whatsoever. Do you understand? Just reiterating that again. Thank you. Sabrina Morris, please. I'm sorry, North Broward? Okay, North Broward.
No, ma'am, we have, Stuart Natasha in front of you.
Okay, and then we need Sabrina Morris, please. Okay, are you Natasha Stewart, ma'am?
Yes, I am.
All right, ma'am, you have one count of grand theft auto. Any objection to probable cause?
There you are.
Yes, ma'am.
Hold on. Court does find probable cause, bond set at $1,000. Anybody wish to be heard?
Yes, Your Honor. I'm going to be asking the court to consider pretrial release for Ms. Stewart. She is a lifetime resident of South Florida. She has 3 children who are currently with her mom, who is disabled. She works cleaning a kitchen in South Beach, and she is going to school at Florida Career College studying cosmetology. She has no prior criminal history, from what she tells me, and a stable resident should be living with her mother, and I believe she's provided that address to pretrial release already this morning.
Okay, state your response.
I would object. She has quite the opposite of no criminal history. 2017 theft, 2016 battery on a public transit employee, violated probation, 364 days county jail. 2016 battery on a public transit employee and theft, VOP, 364 days. Theft, 2016, possession of PVP, 2015, strong arm robbery, 2015, uttering a forged instrument and theft, 2010, resisting without violence and trespass, 2010, possession of marijuana, 2010, battery, 2005.
Okay, all right, the court's gonna leave the bond at $1,000 in place. Ma'am, you're to have no victim contact, direct or indirect, with the alleged victim with the initials JC. That means no contact in person, through third parties, calling, texting, or through social media. Do you understand?
I don't know who that person is, and I just was given the
Okay,
card.
don't talk about the facts of the case, ma'am. Your bond's $1,000. Thank you.
I don't have any money to pay that bond, sorry. I really need a free trial to go home to my children.
All right, well, let's see if someone can bond you out and pay $100, ma'am. Thank you.
No one will.
Okay, Sabrina Morris, thank you.
Your Honor, she is, physically down there at the courthouse.
Okay,
And Your Honor, we also have Arnold Jabon here now for you.
okay, one moment. So,
Okay.
how do I get Miss Morris for this afternoon?
I don't know that we can, Judge. If she's downtown, we don't know how long she's going to take. It might just be easier to reset her for tomorrow.
All right, no problem. So we'll reset for 3:21 a.m. in Central. Okay, no problem. All right, and then do we have Jamon Arnold yet?
Yes, ma'am.
Okay. Hello, sir, how are you today?
I'm doing good.
Good. Do we have Miss Arnold? I know I asked you before, Willie, on our extradition docket today. Okay, no problem. All right, sir, you have an an out-of-state hold from, it doesn't have the state here, I don't know unless someone can enlighten me. Pardon? From Alabama for, thank you, Sheila, for possession of a credit card, debit card. You have a no bond hold. This is an ad charge, so you're gonna be held no bond on this charge pending your other charges being resolved. And if you have you been to extradition court yet?
No, Your Honor. Mr. Arnold has indicated to me he has not. He has resolved his other matters. I would hope we will probably see him Thursday afternoon.
Yeah, we'll see you probably Thursday afternoon, sir, at 1 a.m. for extradition court, okay?
All right.
Thank you, sir. Good luck to you. All right, Harvey Quinney Barnes. Is he still a medical reset?
He's en route, Your Honor. He still hasn't made it yet.
Okay, no problem. Let me know.
Okay. Thank you.
You're welcome. Shanana Peter K. Neal, please.
She's here, President Main Judge. She is approaching.
Okay, good morning. Are you Shayna Petike Neal?
Shanae, yes.
Okay, thank you, ma'am. You have one count of aggravated battery caused bodily harm, We need to talk about bond. Count 2 is touch or strike battery, $1,000 bond. Counts 3 and 4 are basically RORs, criminal mischief, between 200 and 1,000, and resisting an officer without violence. Any objection to probable cause?
No, Your Honor.
Okay, ma'am, I'm going to tell you there's no victim contact, direct or indirect, with the alleged victim in this case, with the initials JST. That means no contact in person, calling, texting, social media, or third parties. Do you understand? Okay. All right, State?
Your Honor, based on, she has a 2007 resisting without violence. Based on the totality of the violence alleged in the entire report and the statements that she made while in the back of the patrol vehicle, I'm requesting a $10,000 bond on count 1, no victim contact, pretrial release with a GPS monitor.
All right, defense?
Judge, in speaking with Miss Neal, she's 30 years old. She's been living in our community now for about 24 years. She is working. She's self-employed. She's a babysitter by trade. Last week, she made approximately $100 for the whole week. Judge, she lives in Sunrise. She resides with her mother. They've been living at that residence now for about 17 years. The only person she's going to be able to contact is her mother. Her mother works answering the phone in customer service. So therefore, the financial resources are quite limited. Judge, we'd be asking you to consider a $2,000 bond on one, $1,000 bond on count 2. That would be a $3,000 bond. She believes that maybe her mother can come up with the premium through the bondsman. If I heard the state correctly, I believe the last contact was back in 2007. Judge, we'd have no objection as far as supervision with pretrial release, but we'd be asking you, Your Honor, to go ahead and consider standard as opposed to level 2. Like I said before, she babysits, so whenever she gets the call, that's when she goes to work. Level 2, I believe you have to give a schedule ahead of time, so that might hinder her ability to support her child as well. So, Judge, at this time, we'd be asking for a $3,000 bond on Ms. Neal's behalf.
Her last contact was a 2011 arrest for domestic violence battery that was dropped.
Excuse me. All right, this is what the court's going to do. The court does have concern. Says the defendant kicked in the front windshield and then attacked the victim with a windshield wiper, striking her face repeatedly. $7,500 bond on 1, $1,000 on 2. I don't need to set a bond on 3 or 4. GPS. I'm going to do a level 2, and she's to maintain 500 feet at all times from the victim in this case.
And, Your Honor, just in an abundance
And that's the victim's work, home, and school.
There's actually 2 listed victims. There's JT is on the first page.
I have JST actually, but
Yes,
that's the same
yes.
person.
And on the second page, there's an FMI. I believe that's the owner of the vehicle from the criminal mischief.
Okay. All right, so the victim contact, direct or indirect, just for clarification, ma'am, is JST and FMI. Maintain 500 feet from both victims' home, work, or school. Thank you. Sabrina Istik.
She's approaching, Judge. She's here at Maine.
Okay. Okay, good morning, ma'am. Are you Sabrina Istik?
Yes.
Okay, ma'am, you are being charged with 1 count of grand theft between $300 and $5,000 from Walmart. Bond is set at $1,000. The court does find probable cause. Anybody want to be heard with regard to probable cause or bond?
Not as to probable cause, Your Honor.
Okay, anybody want to be heard with regard to the $1,000 bond?
Your Honor, she has a warrant out of Dade County for failure to appear in a DWLS from February 21st. That being said, I'd be requesting either a $1,000 bond or RWR to standard pretrial.
Okay, did you hear that?
Yes, Judge, let me talk to Ms. Eastick for her 1 moment.
What's the address of the Walmart? Just give me the street and town.
Judge.
Judge, we didn't be asking you just then to leave the standard bond in place, but we'd be asking you to sign 2 orders. One, to have Ms. Eastick have access to her phone, so she can access the phone contacts, so she can contact her family to have her post her bond, and also number 2, to access her property, Judge.
Okay, no problem, granted.
To answer your question,
Thank you.
it's the Walmart
Hold on,
on
I'm not finished because I want to know return to Walmart.
the Walmart on Pines Boulevard in Pembroke Pines.
Okay, ma'am, you are not to return to the Walmart located on Pines Boulevard where this incident allegedly occurred. Do you understand?
Yes.
Okay, thank you, ma'am. We'll leave the bond in place at 1,000.
North Broward has Mr. Barnes, Your Honor.
Okay, perfect. You're welcome. Harvey Quinney Barnes, please. Is that you, sir? How you feeling today, sir?
I'm okay, I can't complain.
You feeling better?
Yes, ma'am.
Okay. All right, sir, you have a hold for 4 out-of-state holds for felonies for credit card abuse and burglary of a vehicle, 2 counts each. So your bond is set at, on the first 2, at $1,500 each, that's $3,000. Count 3 is $5,000, and count 4 is $2,500.
Okay.
So that, if my math is correct, $10,500 to bond out, okay?
Yes,
If you
ma'am.
can't do that, then we'll see you in extradition court either today or Thursday at 1 p.m., okay?
All right.
All right, sir, we'll see you soon. LaShondra Lavette Johnson,
She's a medical reset, Judge.
okay, Tammy Charia Johnson,
She's probably going to be a medical reset as well.
then we have James Toot Bird,
Judge, he's here present. It's our municipal
oh
ordinance.
wait, this is a municipal ordinance. So let me just see, is this Jara? This is the city of Fort Lauderdale. So this is, okay, have you seen Mr. McLawrence?
Your Honor.
Okay, all right, so what we're gonna do is, we're gonna wait for Mr. McLawrence, he's an attorney that defends people like you for municipal ordinances.
Is there any way I could resolve it today, ma'am?
You can, but I prefer to wait for Mr. McLawrence, so just have a seat, we'll recall, okay?
Thank you, ma'am.
You're welcome. Chad Anthony Elligan,
Good morning.
good morning, how are you?
Pretty good. Municipal ordinance, Judge.
Yep, another one. All right, can anybody call Mr. McLawrence? See if he's on his way? Yeah. Is it Hollywood? Yes, it is. All right, this one. All right, so let me get back Mr. Chad Elligan. That's a Hollywood municipal ordinance. Okay, sir, you were a no-show for an arraignment for carrying an open container. Bond is $100. We can do a couple things today. We could resolve your case for an adjudication, time served, $78 in court costs. I'll give you 6 months to pay that. Do you have anything else pending?
Not that I know of.
Can anybody tell me if there's anything else pending with this gentleman? I just don't want to have him plea out if he's got felonies, huh?
Your bond is $1,000, can you afford it? You have $1,000 downstairs to bond out? Are you on probation?
Ms. Patrice, I think we can hear someone at North Broward. I don't know if it's pre-trial. Where is that? Mr. Romero?
Yes, Judge.
Just to let you know, I think we hear the PD interviewer,
Yeah.
so.
The only other thing I see is another open municipal ordinance that's scheduled for arraignment on April 5th before Judge Backman.
And what is that, a carry in an open?
Trespassing, soliciting, panhandling.
Okay, you have another case, sir, before Judge Backman in the South Satellite Courthouse on April 5th, you said?
Yes.
Do you know what time it is? Does it say?
1:30 p.m.
At 1:30, April 5th, 1:30 p.m. If you don't want another warrant issued, you are going to have to appear and see if you can resolve that case at that time. But as far as this case is concerned, you're charged with an open container. Court would do an adjudication and time served, $78 in court costs. I can't hear you. You got to hit the mic.
All right, thank you.
So what do you want to do?
You said I got another one, April 5th, 1:30?
Yes, but we need to talk about resolving this case, what you want to do with it. Bond set at $100.
I'll take the CTS.
Okay. Raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, ma'am.
Okay, is your name Chad Anthony Eligon, E-L-I-G-O-N? Put your hand down. Is that your name?
Yeah. Yes.
Okay, it's my understanding you wish to waive your right to an attorney and trial in this open container municipal ordinance case. You want to give up your right to have a trial and to have an attorney represent you, sir?
That's fine.
Okay. Is anyone forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
Why are your eyes closed? Is there something wrong?
No, they're open, ma'am.
Okay. I just want to make sure you're okay. You understand that if you're not a U.S. citizen, a plea to this charge can result in deportation proceedings and affect your ability to remain in the United States?
Yeah. Yeah, I understand.
Are you on any medications?
No.
You understand what's going on here today?
Yeah.
Okay, sir. How do you want to plead to open container? No contest, guilty, or not guilty?
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file, finds probable cause for the plea. The court's going to adjudicate you, time serve you, $78 in court costs, 6 months to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. Thank you. You're done, sir. April 5th, 1:30, South Satellite Courthouse, Judge Backman. Melvin Mitchell?
He's here present, Judge Amin.
Okay. Mr. Reedy, while we're doing this, is there any way you can call Mr. McLawrence and find out if he's on his way, or is he sending somebody? If you don't, I can just, after this one, we can take a break and I can call him. Okay. Willie? Which case are you here on? Okay. Okay, Mr. Melvin Mitchell, you have 2 KPS traffics, bonds are set at $250 per count, and you have 2 KPS misdemeanors, $250 per count. That's a total of $1,000 bond. I can tell you, you do have a hearing before your division judge, Jill Levy, on March 26th at 1:30 p.m., which that date is actually this coming Monday. KPSs are for operating without a valid motorcycle license, operating without a valid license, possession of cannabis, and driving while license is suspended. Want to resolve it?
Judge, yes, he wishes to resolve it. I did advise him he had the option of fighting these, but he's advised me he wants to resolve it. He's working at the Golden Corral, and he wants to be out also too, so he doesn't risk losing his job, but he wants to put this matter behind him, Judge.
Okay. All right, also, just to let you know, there was a freeze frame. So, can you see me?
Can I see you?
Yeah, I can't see you.
Oh, you can't see?
As long as you can see me.
Yes.
Okay? Greg again.
Yes, Judge.
Main jail can see me, I can't see them. Okay? Let me just go to Paul Ryan and see. Conti. Broward. Okay. There it goes. Okay, it'll come on in a second. I see the seals. All right, thank you. Bye-bye. All right, we're back. All right, so state, what is the offer?
I'd offer time served on 1 and 2 and 4, and withhold court costs on 3.
Withhold 3 is the possession of marijuana under 20 grams.
Yes, ma'am.
Okay, so this is what it would be. An adjudication in time served on 1 and 2. There would only need to be court costs $308 on count 3 and $293 on count 1. Everything's an adjudication except for the possession.
He wishes to accept the offer, Judge?
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, state your first and last name.
Melvin Mitchell.
Okay, Mr. Mitchell, is it Mitchell?
Yes, ma'am.
It's my understanding you wish,
I'm the third.
the
So
third,
you won't get
okay.
it messed up.
All right, thank
Yeah.
you, sir. You can put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
No, ma'am.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings, sir, and affect your ability to remain in the United States?
Yes, ma'am.
Okay, understanding what I just explained to you. Oh, excuse me, I forgot one thing. Don't we have a... Okay, for the driving while license is suspended, sir, you understand that if you get 3 convictions within 5 years, the Driver's License Bureau will suspend your license as a habitual offender for 5 years?
Yes, ma'am.
Okay, understanding what I just explained to you, still want to plead no contest to operating a motorcycle without a valid DL, operating without a valid license, possession of cannabis under 20 grams, and driving while license is suspended. Wish to plead no contest to those?
Yes, ma'am.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate you and time serve you on 1, 2, and 4. The court is going to withhold adjudication on count 3. On count 1, the court costs are going to be $293. On count 3, it's $308. The court does take judicial notice of Broward County Jail. On count 3, how much time to pay?
Judge is gonna need a year.
Okay, the court will give you 1 year to pay the court costs on counts 1 and 3. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, sir. Thank you. Jason Philip Posner, P-O-S-N-E-R.
Mr. Posner's here present, Judge?
Okay, hello, Mr. Posner. How are you, sir?
Tired.
Sure.
Sleepy.
Okay. All right. You have 1 count of obstructing a highway. You were off the I-95 on-ramp, impeding approaching motor cars. Bond is set, I believe, at $25. Court does find probable cause. What are we doing with this case, Mr. Romero?
Judge, Mr. Posner wishes to ask court if you would consider giving him time served for this case.
If he agrees not to go back to I-95 off-ramp and impede traffic.
Yes.
Okay. Okay, adjudication and time served, the court will give him $293 in court costs. Is that what he wants to do?
Assuming since he wishes to accept the court's offer, Judge.
1 year?
He's gonna, 1 year, Judge.
Okay, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes.
Okay, is your name Jason Philip Posner, P-O-S-N-E-R?
Yes.
Posner, did I say it right?
Yeah, it's fine.
Okay. All right, is my understanding you wish to waive your right to a trial?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
Are you on any medications that would affect your ability to understand what's going on here today?
No.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your ability to remain in the United States, sir?
Yes.
Okay, understanding what I just explained to you, are you pleading guilty or no contest to
No
obstruction?
contest.
Hold on, let me finish. Obstruction of public streets without a permit.
No contest.
Okay, the court's going to accept your plea, find that it's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. The court's going to adjudicate your time, serve you $293 in court costs, 1 year to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. No return to the I-95 off-ramp, sir, where this occurred. Do you understand?
Yes.
Okay. Thank you. All right, William Rashad Lucas, please. We have a private attorney here. Counsel, announce your appearance for the record.
Good morning, Your Honor. Elias Hilal, H-I-L-A-L, on behalf of William Lucas.
Okay, are you Mr. William Rashad Lucas, sir?
Yes, ma'am.
Okay, state, announce your appearance for the record.
Eric Linder on behalf of the state.
Okay, we have, sir, counts 1 through 8, possession, or wait, there's a bunch of them. Okay, we have 1 through 28, sir. Is possession of a weapon or ammo by a convicted Florida felon. We need to talk about bond. Count 29 is remove a serial number from a firearm, $2,500 bond. Count 30, possession of cannabis, 20 grams or less, $100 bond. Disorderly conduct, breach of the peace, $25 bond. And count 32, driving while license is suspended, first offense, $100 bond. And then the final one is count 33, which is resisting an officer without violence, $100 bond. Any objection to probable cause?
Yes, Your Honor. I find objection to probable cause as counts 3 to 28. Florida law states that a defendant cannot be charged with multiple counts of the same charge if it's based out of the same incident. The case I cite to is State of Florida versus Whaley, which says that a defendant with 4 counts of possession of firearm by convicted felon and 1 count of possession of ammunition was improper. In that case, the court dismissed the information because you cannot be charged with multiple offenses. So as it relates to probable causes to count 1 and to count 2, he could be charged independently, 1 with the ammo, 1 with the gun, but count 3 to 24, Judge, are repetitive. And I have the case cite I could present to the court if the court wants to see it. In that case, it went as far as to say, Judge, that it cited also a number of cases, a Supreme Court case, which is Watt, that says that a holding that a defendant could not be charged with multiple offenses for the possession of 2 prison-made knives because that statute at issue addressed any firearm or weapon. as opposed to a firearm or weapon. So it went into the analysis of any versus a. This case is actually very informative. It's a short one, but it goes right to the merit of the case.
Do you have a copy of it?
I do, Your Honor. I have one for the state and one for yourself.
Okay.
May I approach?
Yes. Okay, state.
It's fine, Judge.
Okay, so no PC for counts 3 through 28. Okay, stipulation of the state, and you want me to cite this case? State versus. Okay, so the court's going to find probable cause on counts 1 and 2. And 29, 30, 31, 32, and 33.
Judge, I ask that you set a reasonable bond on count 1 and 2, commensurate with his financial abilities.
Okay, so state, what are you asking for bond on counts 1 and 2?
Count 1, I'm going to be requesting a bond in the amount of $10,000. On count 2, based on the amount of ammunition that was found, Your Honor, $5,000. And I'm making this request based on the totality of the allegations in the probable cause affidavit. Excuse me. Also noting, while not charged with it, I do think it was concerned that he was his attempts to flee from law enforcement to the point of putting his car in reverse after almost striking pedestrians in the street, putting his car in reverse and driving down the wrong way of traffic in the street. Also noting, Your Honor, he was, I believe it's mentioned. One moment, Your Honor. I just want to see if it was mentioned in the report. Yes. Also noting the serious nature of his previous convictions, as mentioned in the report.
Did I ask that if the court would be inclined to set bond in the amount of $10,000 total for the entire case, Judge? I could take testimony as to his relationships to the state, to the county, his ties, his financial abilities.
Okay, the court is gonna order no return. What's the full name of this club, Mr. Linder?
Says it's Club Sway.
Okay, no return to Club Sway. On count one, the court's gonna do an $8,000 bond. Count two, the court's gonna do a $2,000 bond. Okay, and 29 is 2,500, 100 for 30, 31 is 25, 32 is 100, and 33 is 100.
Your Honor, I just asked for an additional release condition that Mr. Lucas not be in possession of any firearms, weapons, or ammunition.
Okay, sir, no possession of any firearms, ammunition, or weapons. Okay?
Yes,
Thank you
ma'am.
very much.
Thank you
Good
very
luck
much,
to
Your
you.
Honor. Thank you.
Thank you.
You attach that. Okay, Jonathan Scott Basungna. Jonathan Scott Basunga, B-A-S-U-N-G-A.
He's here at Main, Judge?
Good morning, sir.
Good morning. Good morning.
Okay, are you Mr. Basunga?
Yes.
Okay, sir, you're charged with obstruction of highway. You're also impeding motor vehicles off the I-95 off-ramp. What are we doing with this case today?
Judge, it's being Mr. Basunga. He wishes to try and resolve this case for time served.
Okay, only if he'll agree not to go back to this off-ramp and explain what happens if I see him here again.
Let me talk.
And I need time to pay $293 as well.
Judge, I explained to him he has no problem not returning to that location. And as far as court costs, we're going to be requesting 1 year.
Okay. Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes.
Okay, you're Jonathan Scott Basunga, B-A-S-U-N-G-A.
Yes.
Okay, put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes.
Anybody forcing you to do this?
No.
Are you under the influence of any alcohol, drugs, or medication?
No.
Ever been treated for a mental illness?
No.
Okay, you want to plead no contest to obstruction of highway, sir?
Yes.
Okay, the court accepts your plea, find that's freely and voluntarily given, adjudicate time served. In addition, the court has reviewed the court file and finds probable cause. $293 in court costs, 1 year to pay. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case. Do not go back to that I-95 off-ramp, okay, sir? Thank you.
Good luck, sir. Thanks.
Craig Joseph Robert Burnell.
He's approaching, Judge. He declined the service of public defender. He's proceeding pro se. Good morning, Your Honor.
Good morning. All right, sir, you have trespass, failure to leave property upon order by owner, $25 bond, and then you actually have 2 municipal ordinance, sleeping or lodging in the open, and disorderly conduct. I can tell you, sir, I do see that you were given 3 prior warnings, and you keep going back there.
Your Honor, I live there across the street on A1A, and as far as habeas corpus, none of this. This is crazy. I live across the street, and those charges are incorrect.
Okay, what's your address, sir?
2080 East Hillsborough Boulevard, Unit 404, Deerfield Beach, Florida 33441.
And do you own or rent?
I own.
Okay, hold on, sir.
Excuse me, Your Honor, that's across the street on the bench that I was sitting at.
Who's the folks?
Excuse me?
Who's the folks? Folkes.
Oh, that is, my mother and her husband,
And what's their first names?
Maddie and Christopher. What?
Well, do you live there or are you at large?
I live at 404, they live at 205. It's a condo unit on A1A, the beach.
Okay,
Why?
because it shows your mother and father as the,
Excuse me? That's
It
not my
should-
mother and father, it's my mother and her husband.
okay.
And their residence has nothing to do with my residence. Why does this have anything to do with, sitting on a bench on the beach? Your Honor,
Just hold on one moment, sir.
thank you very much. Oh, I don't need a lawyer. I have a law degree. Why are you speaking to me, by the way? You speaking to me? You should. Thank you. Yeah, Then I'd like to get into the law, please.
Okay, sir, it shows the owner of apartment 404 as Madeline and Christopher Folks.
No, that was sold to me 6 months ago. Thank you very much.
All right, let me ask you a question, sir. Can you afford a $25 bond?
My wallet is in Deerfield Beach at the police department with my bag. And there's a property slip that shows that. So I don't have my debit card or my $25 with me. And this case should go away based upon habeas savius, right? Habeas savius, this case should go away. Based upon habeas savius in maritime law, this case should go away. Correct?
I don't agree, sir. The court does find probable cause, sir. So,
Habeas
do
savius
you
in
have
maritime
a number where someone could possibly call
No, I don't.
your family
No, I
up?
don't. Excuse me, based upon habeas savius, this case should go away in maritime law, which that is, right? Excuse me, I'm speaking to the judge, please. Correct, Your Honor?
I don't agree, sir. I'm
Okay,
telling
you
you,
wanna
sir,
tell
let
me
me
why.
finish. You asked me a question.
Please.
I don't agree. Court finds probable cause. We're here. This is a
For what?
probable cause. This is a probable
Probable cause
cause
for
here. All right,
For what?
court's gonna keep your bond at $25. Thank you, sir. Good
I'm
luck to you.
asking you a question. For what?
You didn't let me answer, sir. Good luck.
I would like to hear what you have to say.
Cedric DeQuan Coney.
Your Honor, Mr. Comey is in North Broward. They're requesting, and I agree, if we could reset him for this afternoon.
No problem.
Thank you, Judge.
Okay, we have, it looks like Mark Stallworth.
North Broward.
Good morning, Mr. Stallworth. How are you?
Good morning.
You have a no-show for an arraignment for lodging upon property without consent.
I think Mr. Stallworth would like to resolve this matter.
Yeah, it's Hollywood, right, or Hallandale? Just want to make sure it's not Mr. McLaurin, City of Hollandale. Okay. All right, sir, do you want to resolve your case today?
Yes, sir.
You agree not to go back to the property where you were sleeping?
Yes, ma'am.
Okay, raise your right hand. Do you swear and/or affirm to tell the truth, sir?
Yes, ma'am.
Okay, what's your first and last name?
Mark Stallworth.
Spell your last name for me.
STWRTH.
Okay, it's my understanding you wish to waive your right to an attorney and trial and plead no contest to the charge of lodging upon property without consent of the owner.
Right.
Okay, have you ever been treated for a mental illness?
Yes, ma'am.
Okay, does your mental illness, don't tell me what it is, affect your ability to understand what's going on here today?
No.
Are you under the influence of any drugs or alcohol?
No, ma'am.
Are you on any medications?
Yes.
Does your medications that you're on affect your ability to understand what's going on here today, sir?
No, ma'am.
When's the last time you took the medications?
Last night.
Okay. Okay, you understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings, sir. If you're not a U.S. citizen,
So,
understanding what I just explained to you, you want to plead guilty, no contest, or not guilty to lodging upon a property without consent of the owner.
guilty.
Okay, the court's going to withhold adjudication, pose $78 in court costs, take judicial notice of time in the Broward County Jail, give them 6 months to pay the court costs. Okay, sir, you have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. You're done with this case, except for paying the $78, okay? Good luck to you. Don't go back there, sir.
So,
All right. Good luck. Terrell Hillard, and then we have William Allen. Oh, this is Mr. McLawrence, I believe.
Mr. McLawrence was here present, Judge, I mean. And I believe Mr. Hillard just stepped out using the restroom, Judge.
Okay, well, he's a Mr. McLawrence case, so it's a county ordinance. You might want to tell him.
Wait, he's actually here, Judge. Let me get him. They're actually going right now, Judge.
Who? Mr. Hillard?
No, Mr. McLawrence.
Oh, okay.
He's approaching, Judge. He's on his way. In full stride, Judge.
Morning, Your Honor. How are you?
Good, how are you?
Fine, thank you, Your Honor.
I think you have a William Allen that's a county ordinance. Is that yours?
I was told it's a medical reset, Judge.
Okay, so we'll do a medical reset for William Allen. And then we have another one for you, Terrell Hilliard, Hilliard. It's a county ordinance violation.
Judge, he's here, and I also have James Bird.
Okay.
And Mr. Hilliard is on page 10 of the docket.
Okay, I have their cases pulled already.
Okay.
So, Terrell Hillard, any objection? Well, there is probable cause found.
Judge, and just for the record, it's a drink. I have the actual notice to appear, and
Okay.
it's for, I know the docket didn't show what exactly the charge was in that particular case, but it's for drinking alcohol in public.
So
back
an
on
open
December
container.
5th. Right.
Okay.
And I spoke to Mr. Hilliard, and he told me that he just wants to resolve this matter.
Okay, so an adjudication and time served.
Judge, he's in agreement with that.
Time to pay, $293.
It would be 78, Judge.
I'm sorry, so you're right, 78. Thought the county. 6 months.
Yes, Your Honor.
All right, sir, raise your right hand. Do you swear and or affirm to tell the truth?
Yes, ma'am.
Is your name Terrell B. Hillard, Hilliard?
Yes, ma'am.
Hey, put your hand down. It's my understanding you wish to waive your right to a trial, sir?
Yes, ma'am.
Anybody forcing you to do this?
No, ma'am.
Are you under the influence of any alcohol, drugs, or medication?
No, ma'am.
Ever been treated for a mental illness?
Yes.
Okay, does your mental illness, don't tell me what it is, affect your ability to understand the nature of these proceedings today? Let me finish the question with clarity, sir.
I'm all right.
I'm sorry,
your-
It doesn't affect me. It doesn't affect me.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings, sir, and affect your ability to remain in the United States?
Yes, ma'am.
Understanding what I just explained to you, you want to plead guilty, not guilty, or no contest to open container?
No contest.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Adjudicate, time served, $78 in court costs, 6 months to pay. You have 30 days to appeal the sentence to the court. If you can't afford an attorney, sir, one will be appointed. Thank you. You're done with this case, except for paying the court costs in 6 months. Thank you.
Thank you, ma'am.
Thank you,
Okay,
Judge.
what about James Tut Bird?
He's here, Judge.
Are you Mr. James Tut Bird, sir?
Yes, Your Honor.
Okay, you have two violations of municipal ordinances. One is false 911 calls, and count 2 is disorderly conduct.
And Judge, I went over the probable cause affidavit with Mr. Bird, and we don't have an objection as to probable cause. He told me, he admitted that he was under the influence of alcohol when this happened, and he apologized for it, and he wishes to resolve this matter, Your Honor.
I do apologize, Your Honor.
Okay, you're not gonna make any more false, calls, sir?
No, Your Honor, and I do apologize.
BYRD, Bird. It's a two municipal ordinances.
It's on page 8 of the docket.
Okay, this is what the court will do. The court will adjudicate and time serve. Court costs on one count only.
Thank you, Your Honor.
Is that what he wants to do, Mr. McLawrence?
Yes, Your Honor.
6 months to pay?
Yes, Judge.
Okay, sir, raise your right hand. Do you swear and/or affirm to tell the truth?
Yes, Your Honor.
Is your name James Tut Bird, BYRD?
Yes, Your Honor.
Okay, it's my understanding you wish to waive your right to a trial.
Yes, Your Honor.
Anybody forcing you to do this?
No, Your Honor.
Are you under the influence of any alcohol, drugs, or medication?
No, Your Honor.
Ever been treated for a mental illness?
No, Your Honor.
You understand that if you're not a U.S. citizen, a plea to this charge could result in deportation proceedings and affect your
Yes,
ability.
Your Honor.
Let me finish. And affect your ability to remain in the United States, sir?
Yes.
Okay, understanding what I just explained to you, are you pleading guilty, no contest, or not guilty?
No contest, Your Honor.
Okay, the court's going to accept your plea, find that's freely and voluntarily entered. The court has reviewed the court file and finds probable cause for the plea. Adjudicate on each count, time served on count 1 and count 2. Court costs on count 1 only $78, 6 months to pay. You have 30
Thank you,
days
Your
to,
Honor.
hold on, sir. You have 30 days to appeal the sentence of the court. If you can't afford an attorney, one will be appointed. No more 911 calls, sir, that are false, okay?
Yes, Your Honor.
Thank you. Good luck
Thank
to
you.
you.
Thank you, Judge.
Have a good day. All right, Terrence Everett Mitchell, please.
Mr. Mitchell is in Conte, Judge. He declined our invitation to attend court this afternoon or this morning.
Mr. Terrence Everett Mitchell, deputy at Conti, did he refuse?
Yes, ma'am.
Okay, Mr. Mitchell voluntarily absented himself from the court. Court does find probable cause. This is an ad charge. Bond set at $1,000. It will remain. Anything else, State?
No, Judge.
Just so the record's clear, Judge, Mr. Mitchell does have no bond holds on counts 6 and 7. So his failure to appear does not really affect his bond status.
Okay. All right. Thank you. Next one is Yeshua Jericho Banner.
Your Honor, I just got off the phone with North Broward. They are having an issue with their generator. They're asking for cases to be placed on recall. They'll notify me when they're back up and running.
Okay. Richard Wesley.
Conti?
Okay, Mr. Wesley, you have an ad charge, I believe, sell cocaine. Bond is set at $2,500. Court does find probable cause. Anybody want to be heard with regard to the $2,500?
Your Honor, Mr. Wesley has a no bond hold on count 2. Would ask the court to leave the bond where it is so we can resolve everything in front of his division judge.
Court will set the bond at $2,499. Thank you.
Your Honor?
Yes,
Is there any chance we can call Elijah Morgan?
absolutely. Is that the last one?
Yeah, he was.
No problem. You know what page he's on, anybody?
I think it's the last.
24. It's the last case on the docket.
Last case. Okay. All right. Are you Mr. Elijah Gregory Moran?
Yes, ma'am. Yes, ma'am.
M-O-R-A-N?
Yes, ma'am.
Okay, I thought he said Morgan. All right, sir, you have some capious ad charges. Count 10 is a firearm by a felon. We need to talk about bond. Count 11 is grand theft, 3rd degree. $6,000 bond. Counts 15, 16, 70 is capious felonies. 15 is the ad charge, $1,000 bond. 16 capious felony is $25 bond, and count 17 capious felony. We need to talk about bond.
Your Honor, on the charge 10, bond was originally set at $10,000. It's a lateral change of charge. I'm going to be asking that the bond be placed back on him at $10,000. Count 11 was originally set at $5,000. I'm going to ask that that bond be kept on him. Charge 17, the burglary dwelling, I'm going to be asking for a $10,000 bond. Your Honor, I would note, Mr. Moran, these cases have been assigned to career offender court. Additionally, he's being held no bond on an armed burglary. He's got a total bond of $10,500 on 3 dealing in stolen property, $20,000 bond on an occupied burglary of a dwelling, $5,000 on another grand theft, and he's also being held no bond for probation violations, 3 separate, probation violation for burglary of an occupied dwelling.
So it's somewhat of a moot point as to what bond the court actually sets. Mr. Moran does have a court date coming up on March 26th, and that's where he will need to address his bond issues.
Okay, I can tell you 11 and looks like 15. Court's going to set 11 instead of the 5,000, the 4,999, and count 15, $999. Okay? Thank you.
Thank you.
Thank you, ma'am.
James Alfred Patricio.
Your Honor, I'm sorry.
I'll tell you why later.
No, it's not that. I just didn't know what bonds were set on 10 and 17.
The one for 5 and 1.
I'm sorry.
5,000 and 1,000. Went down $1. James Alfred Patricio.
Mr. Patricio is here at Main, Judge?
Okay, are you James Alfred Patricio, sir?
Yes, ma'am.
Okay, sir, you have count 1, battery on an officer firefighter. We need to talk about bond. Count 2 is basically, there's no bond attached to it. It's disorderly conduct. Any objection to probable cause?
No, Your Honor.
The court does find probable cause. Court is going to order no victim contact, sir, direct or indirect, with the alleged victim in the case with the initials JD. That means no contact in person, calling, texting, social media, or through third parties. Do you understand?
Yes, ma'am.
Okay, the second thing is you're not to return to the Courtyard Marriott where this alleged incident allegedly occurred, which is 440 Seabreeze Boulevard, Fort Lauderdale. Do you understand, sir?
Yes, ma'am.
Okay. All right, so state, let's talk about bond on 1.
Your Honor, I'm going to be requesting a $1,000 bond based on the allegations and booking, and the reports show a Fall River, Massachusetts address, so it does not appear he has ties to the community.
Okay, so $1,000 you said?
Yes, ma'am.
Okay, defense?
Judge, under the circumstances, we feel that's reasonable. We'd just be asking you to sign a photo order so we can photograph Mr. Patricio's injuries, and he did give me his phone number of his family that I'm going to be contacting after court.
Okay. All right, thank you. Patrick J. Thompson.
Mr. Thompson, no, please. Thank you.
Okay, Mr. Thompson, you are charged with 1 count, burglary, occupied conveyance, unarmed. Any objection to probable cause?
I know the probable cause affidavit uses the word attempted quite a lot throughout the body of the language of the affidavit itself.
I knew you were going to say that. Okay. State?
It's an attempt, man.
All right. All right, so what are we doing about bond, folks?
Your Honor, despite the fact that it's an attempt, I'm going to be requesting a $3,500 bond, no victim contact. He has a misdemeanor possession of cannabis 2013 out of Ocala, possession of cannabis 2010 out of Dade. Really, my concern in this case is the allegation that the vehicle was occupied when Mr. Thompson attempted to break into it.
Yeah, that's my concern here, folks. He reached inside the front passenger window of the car, I'm paraphrasing, and attempted to open the front door from the inside with the victim sitting in the front driver's seat. Okay, defense, Mr. Romero, $3,500 bond they're asking for.
Judge, in speaking with Mr. Thompson, he's strenuously denying the allegations. I did inform him he'll have his day in court to present his side of the story. In saying that, Judge, this is a third-degree felony. It's an attempted. Judge, we'd be asking you to set a $1,000 bond on Mr. Thompson's behalf.
Where is Chiefland, Florida? I've never even heard of that. North Florida? Does he live, where's his address?
Chiefland.
Is that Chiefland or Chiefland?
It's
Liz? Okay.
Judge, Mr. Thompson's basically right now, he's relocating. He's moved down to South Florida, specifically Opelika. The purpose of him moving down to South Florida is he has kids. He's trying to go ahead and go through custody, trying to see more visitation of his children, Judge. He's obtained employment in Miami-Dade County in construction. Since he just moved into the area, Judge, he just got a job. That's why he doesn't really have the financial resources. That's why we believe $1,000 bond on an attempted third-degree felony is reasonable under the situation, Judge.
Where does he live? What's the address?
How's her apartment?
It's an apartment with my brother, my older brother.
It's an apartment with his older brother. It's in Opelika, as I said before, Judge.
He's the one who's providing me the job. They're using the transportation for me to back and forth to work.
Judge, and from what he advised me, is fortunately his brother is helping him out as he transitions here to Dade County. He's provided him with a place to stay, and he's the one that actually provided the employment for him in construction, Judge.
Okay, $1,000 bond, no contact, direct or indirect. GPS level 2. Thank you.
Judge, would you do an open schedule? Because as far as the hours with him working,
What does he do?
construction.
I work 10-hour days. I have to work 10-hour days.
State, you have any objection to an open schedule?
well, I mean,
They'll know where he is.
that's fine, Your Honor.
Okay, then we'll change it to an open schedule. Joseph Michael Sustakowski.
He's approaching, Judge. Morning, ma'am.
Hi, how do you say your last name? Sustakowski?
Sostakowski, ma'am.
Sustakowski, okay. All right, sir, you have one count, KPS traffic, which I've been told you bonded for 500. And then you have corruption by threat, public servant or family. We need to talk about bond. Any objection to probable cause for this ad charge?
It's not clear to me where this happened.
It actually happened when he was surrendering himself on the capias, Judge. And when I reviewed the PC report, that was conveniently left out, Judge. That's right.
Yes, I would say that was conveniently left out.
Okay, say that again. So repeat yourself again.
He was surrendering himself on the capias when this alleged confrontation with the BSO deputy took place.
I didn't realize, and I'm addressing this to the court, That's not an element of the crime. Law enforcement is required to mention the elements to establish probable cause. It clearly establishes 555 Southeast First Avenue is, that's where he was surrendering himself, Your Honor, so it's clear the location.
Oh, I didn't know 555 Southeast First Avenue was a jail.
Well, now you know.
Now I know. And it's no thanks to Deputy Felowski that I know, because he left it out of the report. In any event, Judge, I think it's a mitigating circumstance that he is turning himself in on the capias. I don't know what happened with him and this deputy, but it looks like there was no violence involved other than language. And I'm sure the deputy also conveniently left out anything he may have said.
Your Honor, I'm gonna.
The court's gonna find probable cause. What are we doing with bond?
Your Honor, I'm gonna be asking for a $2,500 bond. He is, as the officer mentioned, he is qualified as a violent career criminal. He's been to state prison. He's been to state prison on a habitual offender. He's
But
been
he
qualified.
did turn himself in.
My concern isn't that he turned himself in, it's what he did after he turned himself in and started threatening to kill a police officer. Or, actually, Your Honor, made threats made threats of violence, Your Honor.
Okay,
Clearly.
that I can agree with.
Okay, defense?
Judge, in speaking of Mr. Satowski, there's always two sides to every story, and hearing his story, there certainly is two sides, but I did advise him today's not the time and place. But Judge, asking you, is he saw that he had an outstanding capias. Him and his girlfriend basically saved up so that she can afford to bond him out. Unfortunately, they've used up their financial resources in posting the bond on count one. Judge, he just got a job right now. He's working for an AC refrigeration company. He just started. He lives in Plantation with his girlfriend. He's 53 years old. From what he advised me, even if Your Honor were to consider placing a $1,000 bond, that's going to be something very difficult for his girlfriend to post bond. Judge, I'd ask you at this time to take into account what my colleague advised you as far as for mitigation purposes. He did turn himself in. He's going to come to court. He's looking forward to contesting these allegations, Judge. I'd ask you to consider placing him on standard pretrial.
Okay, let me just tell you on the traffic, let's start with that one, the easy one. He did bond out on it. He does have a court date before Judge Robert Diaz this Monday at 11 a.m. He misses that court date. He's going to be, Judge Diaz is going to issue a capias. So it's Robert Diaz this Monday, March 26th at 11 a.m., which is up on the 6th floor of the new courthouse, okay?
And I'll write that down.
Okay.
Thank you very much.
That's Division MJ Robert Diaz, 6th floor. As far as the, let's see. Okay, so you're asking for $1,000, state's asking for 25, you said?
Yes, ma'am.
And you're asking for $1,000 or standard pretrial?
Let me see if he can even come up with $100. Hold on one minute.
Well, he paid the 5 already, so.
Judge, I believe, like I said, they used up their money to bond him out on that. They had a game plan. He went and surrendered himself. Judge, we're going to be asking for standard pretrial.
I'm not going to give him standard pretrial. It's either an ankle monitor or $1,000 bond.
Let me talk. I'll do the ankle monitor. Oh, okay, he'll do the monitor, Judge.
Okay, GPS open schedule. RR. Make sure he doesn't forget about Monday. Thank you.
Thank you.
One moment. We're going to go. Jordan Diaz, D-I-A-S.
Mr. Diaz is present with us, Judge, in Maine.
Okay, Mr. Diaz, you charge with count 1, battery on an officer, firefighter, EMT. Count 2, resisting an officer with violence. We need to talk about bond. Bonds on count 3 and 4 are trespass property, not a structure or conveyance, $25, and resisting an officer without violence, $100. Any objection to probable cause?
No, Your Honor.
Okay, the court does find probable cause. State?
Would be requesting $1,000 bond on 1, $500 bond on 2. And
How much on 2? I'm sorry.
500 and,
So 1,500.
yes, ma'am.
Okay, defense?
Hold on one second, Judge. Judge, under the circumstances, we feel that's reasonable what the state suggested, $1,500 on 1, $500 on 2. We only also be asking for a photo order as well, Judge.
Okay, the court will sign a photo order. Don't forget, there's a 25 and a 100. So the total is $1,625.
No return to
1,625.
St. Andy. I don't know if you
Lives
already
there, I
ordered it.
think. That's why I'm trying to figure, that's the next question.
No, he was trespassed. No, I don't believe so.
Well, St. Andrews is 50-something hundred, is 5,400 Lyons Road, and it has him as 4518 Northwest 51st Court, Coconut Creek. Is that your address, sir?
Yes, ma'am, that was my address, but I was currently looking for a place in Boca where I'm working now.
Okay, do you have an address where you can receive mail, sir? That I can update your address to make sure that you get court notices so there's not an issue with you getting a warrant for your arrest because you didn't get notice and you missed court.
You can send it to that same address, ma'am, then I'll receive it.
You will receive it?
Yes, ma'am.
Okay, is there any apartment number attached to that?
No, that it's a house, ma'am.
Okay. All right, so no return to St. Andrew Apartments, you understand, sir?
Yes, ma'am.
And that's in Coconut Creek. Okay, $1,000 bond on 1, 500 on 2, 25 on 3, 100 on count 4.
Thank you, sir.
Your Honor, I've been on the phone with North Broward.
Yes, sir.
They're going to ask that the remaining 2 cases that we have be rescheduled for this afternoon. They're putting in a new generator or something along those lines.
Okay, so let's just go to that for 1 second. Let's see if we have someone there. Nope, it's off.
No, they're off. We have Mr. Banner on page 12.
Okay, so Mr. Banner reset for 3:20:18 p.m.
And I believe the other one is Khalid Webb Bryan on page 18.
Okay, that's the second one.
And I think that's it.
Reset, 3:20 p.m.
Yep.
Brian, Khalid, Rashawn, and Webb.
Banner. Banner's on page 12,
And then there's Webb Brian, Sheila.
and
But
he's
there's
on page 18.
The Webb is dash Brian, B-R-Y-A-N. Did you find it? Yeah, Brian, B-R-Y-A-N. Edward Christie, and then
He's here, ma'am.
Keelman Hall.
Judge, he declined to serve as public defender.
Okay, are you Mr. Edward J. Christie, sir?
Yes.
Okay, sir, you have count 1, assault. That's basically an ROR, no bond attached to that, as well as counts 2 and 3 are the same. Disorderly conduct. And count 3 is resisting an officer without violence. Corruption by threat of a public servant, though, we need to talk about bond. Court does find probable cause. Court is going to order you, sir, to have no victim contact direct or indirect, with the alleged victim with the initials RJJD. That means no contact in person, calling, social media, or anything like that. Do you understand, sir?
Yes.
You're also not to return to the Winn-Dixie, which is located at 3435 North Federal Highway, Pompano Beach, Florida, 33064. State, what are you recommending for a bond on count 4?
I'm gonna recommend a $100 bond on count 1 and a $1,000 bond on count 4. Your Honor, Mr. Christie is in this division frequently. This is his 5th arrest this year. It's his 10th arrest in the past year.
5th arrest this year?
10th arrest in the past year, 5th arrest this year.
Okay, so what are the 5 arrests for this year?
He's arrested.
You don't have to give me the dates, just.
Okay. One was on a municipal ordinance open container. Another was on a trespass. Another was on a trespass.
And the last one's a felony, so we can't send it to Lerner Wren.
They were all trespasses except for the open container.
What about last year?
He had a criminal mischief at a speedway that was actually resolved in your division, Judge, where he pulled a service window tray completely off the tracks. Let's see.
All right, so sir, they're asking for an $1,100 bond. Count 4 is a felony. Do you have any response, sir?
What I'm gonna do? They make stuff up as it goes. So
Okay, sir, just
doesn't
hold
matter.
on. I'm not asking
You
about
got a badge, you can make up anything. He's the one that jumped on me. I'll start it with the disorderly conduct.
Okay, sir,
Like-
don't talk
like I'm
about the
gonna
facts of
resist
your
to
case.
that.
We're just here to talk about the bond.
It don't matter. They make it up as they go. So it really don't matter. Why would I resist on disorderly conduct? No, he jumped on top of me, and that's the way it went. And I'm not going to lie about it. But they can do it and get away with it.
All right, this
They
is
do
what
it all
the
the
court's
time.
gonna do. Can you forward any bond at all? Do we have anything for Ms. Patrice?
Listen, I'll live here. I'll live here until I go to prison. How's that? Does that work for you? Because I guess that's what they're after anyway. So, listen, I'm not one to fight them. I'm a loser to begin with. But they can make up stuff, jump me, and they get away with it. Why would I resist for disorderly
Sir,
conduct?
just hold on. Quit while you're ahead, okay?
Listen, I'm
Sir?
doing fine.
First of all, you have a right to an attorney if you can't afford one. Clearly sounds like you can't afford one. Just listen to me for a moment, sir. Don't respond, okay? Clearly you cannot afford an attorney.
Clearly.
So,
Since I'm homeless, I guess that's a no-brainer there.
all right, but you're not using the services of the public defender, and if you apply for them,
You know what? At this point, I got sold out last time for a battery on a Leo, because again, he made it up, sitting in his car behind the windshield, but I spit in his face. Explain that one to me. Public defenders are terrible. I'll just do it on my own. Because they make it up as they go. Last time, battery on a Leo, he's in his vehicle, behind the windshield. I spit out the window, but I spit in his face. Explain that one to me. Explain that one to me.
okay, this is what the court's gonna do. The court's gonna do a $1,000 bond. The court's gonna leave 1, 2, and 3, no bond attached to it. Count 4, the court's gonna do a $1,000 bond, or he can do standard pretrial. But this is the thing, sir. If I put you on standard pretrial, how are you gonna find out your court date? Because obviously there's no address where they can be mailed unless you can give me an address.
I have my mailing address, which is Presbyterian Church on Federal Highway. I believe I gave it to the court before.
But it only changes it in the case. So let me ask you, what's your address? Do you know it?
5555 North Federal Highway. It's a Presbyterian church. Is where I get my mailing address.
Okay, where is that?
Fort Lauderdale. 33308. And they use, I guess, like an apartment number 15. It's not really an apartment. I don't know what kind of number it is, but it's number 15. I don't know what that is. But it is a Presbyterian church. I believe the court has got that address from previous case. I do work every day. I go to a day labor.
Okay, sir, well, your court date, I'm going to have the clerk update your address to this 5555. That's 45 North Federal Highway.
I have a court date this Tuesday for the trespass, the 27th. I do have a court date.
Okay,
already.
well, this is going to be a different case, okay?
Well, I understand that, but I've
All
got
right,
a court
so you're
date.
going to have to keep up with this. So you can check also, if you go to the public library, you can check the computer. All right,
Okay.
sir?
Yep.
I'd highly recommend, sir, that you contact the public defender's office. They are good attorneys, okay? If you don't want to, that's your business, but you should fill out an application. Good luck to you, sir.
All right.
Cleo Min Paul.
Mr. Paul is here present. Judge, he declines service to public defender. He has private counsel, Mr. Joshua Fishman.
Anyone know Mr. Joshua Fishman? Where is he out of, sir?
It's Joshua Fisher.
Joshua Fisher. Can someone call him and tell him we have his client here on a attempted first-degree murder case? Sir, don't talk about the facts of your case. We're trying to get a hold of your attorney. Everything's being recorded here today. Anything you say can and will be used against you. Is someone calling Mr. Fisher? Okay. All right, sir, have a seat. We'll recall your case. We're trying to get a hold of Mr. Fisher. Sabato Santonio Bridges.
I've been informed he bonded, Judge.
He bonded, okay. Moving right along. Austin Dwayne Lewis.
Mr. Lewis is approaching, Judge. He has private counsel, Miss Lisa Stewart.
Okay. Does Miss Stewart know you're going to be here today, sir?
Yes.
Where's Miss Stewart out of, sir?
Shannon Brower.
Mr. Reading. Lisa Stewart, let them call. I'd prefer you call. All right, we're going to recall your case, sir. Trying to get a hold of your attorney, okay? Louis Paul Chickless. He has a violation of parole.
He's approaching, Judge.
Okay.
He's here present, Judge.
Okay, you have a violation of parole, Mr. Chickless. You're being held no bond, and the parole board will be in touch with you. Thank you. Philip Alfonso Cunningham.
Judge, he's asking he wishes to ask the court a question. Can I just ask what's the violation for, man? No one's told me what I did to violate parole.
It doesn't say the parole board or Department of Corrections put a hold on him.
Just says, subject is wanted for parole violation. Please confirm via teletype. So you're gonna have to take that up with them.
All right, Your Honor. Thank you.
You're welcome. Good luck to you.
Your Honor, I spoke with Ms. Stewart.
Okay.
She's asking for Mr. Lewis to be reset to 1 o'clock.
Okay, let's call Austin Dwayne Lewis, please. Thank you, Mr. Reedy, by the way.
You're welcome, Judge.
Okay, we got a hold of your attorney, Miss Lewis. I'm sorry, Miss Stewart, Lisa Stewart. And we're gonna reset you for this afternoon, sir, okay?
Okay.
Around 1 p.m., but we run a little bit late because we do extraditions first.
No problem.
All right, we'll see you around 1.
Thank you.
Philip Alonzo Cunningham.
Mr. Cunningham is here, present, Judge Amain.
Okay.
He's approaching, Judge.
Yes, ma'am. Yes. Thank you, Sheila. All right, so we have Mr. Cunningham, count 1, gambling or games of chance, $25 bond. You actually had an out-of-county hold from a felony out of Dade County, and confinement advised me that they dismissed the $7,500 bond, that it's only a pickup in Dade County. Okay, so charge is still pending for the, do we know what kind of charge it is? Okay, it's a driving while license is suspended, sir. So if you're in Dade County, sir, you're gonna be, have to deal with that charge. But in any event, any objection to probable cause?
No, Your Honor.
Okay, court finds probable cause. Want to be heard with regard to the $25 bond, Mr. Romero?
Judge, since he has something, I guess potentially pending in Dade, it wouldn't be probably a good idea for him to resolve it. Judge, considering this is a
It's
misdemeanor
dismissed.
It's dismissed?
Well,
Okay.
the $7,500 bond is dismissed. He still has the case pending.
Okay.
It gets
Right.
picked up in Dade. It's only a Dade County warrant.
Since he still has a case pending in Dade, Judge, we'd be asking you to consider an R warrant count 1.
Can you afford a $25 bond at this point?
Yes, Judge.
Okay, then the court's gonna leave it at $2,500. Thank you. I mean, $25. Delion Jamal Jones. Does he need access to his property? Mr. Romero?
ID.
Okay.
So, no, they got my phone and everything.
In here?
No,
Okay. No order, Judge.
Okay, thank you. Delion Jamal Jones, please, and then we have Odell Hood.
Judge, in reference to Mr. Jones, we'd be waiving formal reading of the charges.
Okay, court finds any objection to probable cause? Oh, no, it's a warrant.
It is a
Forgot.
warrant.
Thank you. State?
Honor,
We have counts 1 through 7 only, okay.
yes. Based on the allegations, Your Honor, I'm going to be requesting bonds in the amount of $10,000 per count, no victim contact, pretrial release with a GPS monitor.
I would just add before Mr. Romero provides the court with information about Mr. Jones' ties to the community that the evidence against Mr. Jones in this warrant is the unsubstantiated testimony of the alleged victim in the case, which was not borne out, not that necessarily would be, but even based on a forensic examination, there was still no evidence to support her contention. So I think that's something for the court to take into consideration when setting bond in this matter.
Okay, state your response.
Your Honor, I believe there's more than that. Mr. Jones gave a statement claiming that he's never even met her. However, she gave a statement describing his home.
All right, so what are you requesting as far as bond? I got yours, 10,000.
Yeah, I know.
And what about no victim contact, direct or indirect?
I asked for that. It's
I didn't hear you
yeah,
say
no
that.
victim contact, pretrial release of GPS monitor.
Okay, give me the initials.
One moment, Judge.
Sir, you're to have no contact with the alleged victim. I'm gonna tell you the initials in a moment. Direct or indirect, that means not in person, not calling, not texting. It's really important, sir.
HB.
No, H what? The alleged victim's initials are HB. That means no calling in person, no texting, no calling, no social media, liking, disliking, and no contact through third parties. Do you understand, sir?
Yes, ma'am.
Okay, the court's going to do a GPS level 2. Defense?
Judge, in speaking Mr. Jones, he's been residing in South Florida his whole entire life. He's 29 years old. By trade, he's a writer. So from what he informed me, last month he made a total of $700. So there's not much there. He lives with his mom in Opelika. His mom is elderly and she is retired. Therefore, he's going to be relying on his mother to help post his monetary bond. But I believe from what the state has suggested, $10,000 on each count, $70,000 is going to be something totally out of reach for him and his family. Judge, I'd be asking you to consider a $2,500 bond on counts 1 through 7. If my math is correct, I believe that's $17,500, along with level 2 in pretrial, as the court already mentioned. Judge, we believe that would be reasonable under the situation.
Okay, court is going to no victim contact, direct or indirect, with the alleged victim with the initials HB, GPS level 2, 10,000 on counts 1 through 7. Thank you. Okay, Odell Hood, please.
He's here, President May.
Okay, Mr. Hood, you have possession of MDMA, ecstasy, $1,000 bond. Count 2 is possession of cannabis, 20 grams or less. No bond attached to that. Court does find probable cause. Anybody want to be heard with regard to the $1,000 bond? Mr. Romero, okay, court's gonna leave the bond at 1,000, thank you. Floyd Duran Phillips.
Mr. Phillips, you're next.
Okay, good morning, Mr. Phillips. You have operating without a valid DL, $25 bond, capious misdemeanor, $500 bond. Then you have a capious felony, you have a no bond hold. You did not show up for arraignment.
Can I say something about that?
No. You're gonna have to deal with your division judge about that, unfortunately, sir. So the only thing that we're here today on is the operating without the valid DL and the capious misdemeanor.
Judge, considering he has a no bond hold on count 3, the defense has nothing to add in reference to count 1 and 2.
Okay, court finds probable cause. The court is gonna leave the bond at $25, at $19 on count 1 and the capious misdemeanor, $499. Thank you. Kenneth Bernard Johnson, and then we have Alexandra Nicolay Bello-Zurva.
Mr. Phillips here present, Judge?
Mr. Who?
Mr. Johnson, I apologize.
That's okay. I thought it was me. Maybe I said the wrong name.
No, that one was me.
Okay. For once. Okay. All right, sir. You're charged with grand theft between $300 and $5,000. Bond's been set at $1,000. Any objection to probable cause? There you go. Okay, can he afford
Any
the
objection
$1,000?
to a, you said any objection to probable cause, right, not to the bond, right?
Correct.
Okay.
All right, court finds probable cause. Can tell you there's no return to the Walmart, 2300 West Atlantic Boulevard. You understand that, sir?
Yes.
Okay, let's hear you with regard to bond, Mr. Romero.
Judge, we're going to be requesting you release Mr. Johnson on standard pretrial release. He's 29 years old. He works in construction, been doing that for about 1 year
No
now.
objection. Standard
Thank you,
pretrial
Judge.
ROR.
Your Honor,
Okay.
if we could
Let me give you a minute.
Just hold on just one
No,
moment.
nothing on this case.
Hold on. What?
I'll wait till we're done with this
I
case.
just
Okay.
wanted to verify his address. Mr. Romero, hold on. I don't want him to leave. Is your address 210 Northeast 3rd Street?
Yes.
Okay.
Your Honor, I just asked for no return to the Walmart on Atlantic.
I said that.
Oh, okay.
You missed it.
Yeah.
Okay. No return to the Walmart.
We can recall Cleoman.
Sure. Let me see. Who is this?
Cleoman Paul, Mr. Fisher's number. He's having food poisoning. He can't physically appear.
Oh, he wants me to call him?
Yeah.
Okay, let's call, or let's just finish these couple and then we'll call so Mr. Romero can go. Lori Metire,
Bond's posted.
bond has been posted.
Good news. Good news.
Good luck, sir.
So I'm not going to call your.
Hold on a second. Tell him to come back
Oh, wait.
for 1 second.
Mr. Mattia, come on back. Come on back.
I just want to verify I have 2 addresses here. I want to make sure he gets noticed.
1130 is the wrong one. 75, 29 Northwest 44 Court
Okay,
Spring. That's
hold
my
on. Give me a second. I'm writing this down, okay? Just want
Yes,
to make
ma'am.
sure you get notice. All right, say the address slowly because I'm writing it.
7529 Northwest 44th Court.
Town?
Ma'am?
Town?
It's Cold Springs. Apartment 1.
Zip?
33065.
Okay, you're done. Good luck.
All right, thank you.
Thanks.
Judge, I believe you called somebody and then you just skipped them, Mr. Alexander Belazaroff.
Yes.
Do you want to do him now?
Sure.
Mr. Belazaroff, come on up.
Okay, Mr. Belazaroff. Is that the way you say it?
That's fine, that's fine.
Okay. So, sir, you are charged with failure to redeliver a hired vehicle. Court does find probable cause. Court is going to order no return, sir, to the Hertz rental car located at 5400 Butler National Drive, Orlando, Florida, and also the one in Fort Lauderdale.
I wasn't going to even make a request on the Orlando. I think that's probably their national headquarters.
Yeah. All right, so no return, sir, to the Hertz rental car, okay, while this case is pending. Okay, anybody want to be heard with regard to the $1,000 bond?
Yes, Judge. And speaking of Mr. Belazaroff, my understanding is this is his first criminal arrest.
So what are you asking for?
To a felony. Judge, we're going to be asking for an ROR, and here's why. He's 37 years old. He has a job. He's worked for Florida Casino Nights. They set up, like for non-for-profit organizations, they set up a whole casino for fundraising. He's part of the person that sets up the equipment. He's been there for about 1 year now. He lives in Hallandale by himself. He rents an apartment, it's $500 per month, and he's been living there for about 1 year. Judge, like I said, he's a registered voter here in Broward. This is his first, he has no prior criminal convictions. He's a registered voter here in Broward. Judge, my understanding is once all the facts come out, it's a Hertz rent-a-car. He gave his information, so he's not trying to run. I believe he may have had it for about 3 weeks. He thought maybe that they were still billing him. He's going to have his day in court. This is a non-violent offense, Judge. He's not running what you consider straight ROR.
What's his address?
What's your
450 Lane Boulevard, apartment 3, Hunter Beach, Florida, 33009.
State?
Discretion.
ROR, no return to Hertz.
Thank you, Judge.
Thank you. Make sure you check your court date, sir, because if not, you're gonna have a warrant out even if you don't get it. Bobby
Thank you.
Lee Quimbley? Did you need me for something, Sheila?
Mr. Quimbley is here present, Judge.
Oh, yeah. Okay, Mr. Quimbley, you have count 1, trespass, occupied structure, conveyance, $100 bond, parole violation. It's actually a parole, probation violation, not parole. You are going before your division judge, who is Judge Joffrey Cohen, on April 2nd at 9:45 a.m. You are going to be held no bond pending that hearing. The trespass, the bond is $100.
I'm sorry, I'm actually going to be asking for a bond increase. The reason being
On what?
the trespass.
All right, just let me finish 1 second. So there's no victim contact, direct or indirect, with the alleged victim with the initials GME, direct or indirect, sir, means no contact in person, third parties, social media, liking, disliking, like on Facebook and the like, and no calling or texting. Do you understand?
Yes, ma'am.
Okay, and there's no return to the address at 337 Northwest First Terrace. Do you understand?
Yes, ma'am.
That's in Deerfield Beach.
Yes.
Okay, State, you want to be heard with regard to count 1?
Yes, Judge. On count 1, I'm going to be requesting a $5,000 bond and a pretrial release of the GPS monitor. The case that Mr. Quimbley is on probation for felony battery involves the same victim as his home. The allegations in that case is that he entered this woman's home and committed a felony battery, the case he's on probation for. He was already trespass warned not to return to that home at the time of the 2016 incident. And he continues, even being on felony probation in domestic violence court, he keeps going to this woman's home. I do have concerns going forward for this woman's safety, considering he won't follow not only court orders, lawful orders from law enforcement, but also court orders.
Okay, is this the same as a domestic violence injunction?
I'm sorry?
Is Jermaine Epps
Is
the person who he has the probation violation in front of Judge Cohen? Does it have to deal with that?
Yes, it's the same victim.
Okay, so 5,000 GPS level 2. All right, defense?
Judge, it's trespass. He has a no bond hold. He's not going anywhere. We'd have to just leave it the same. He's 58 years old. He just got a job landscaping. There's no way he can afford to be on post a $5,000 bond. And Judge, if you put him on level 2 pretrial, he's already on probation, so he'll be supervised anyway, Judge. So we just have to leave the standard bond alone.
Okay, here's the thing. Keeps going back to this person's residence. He has a restraining order. And
that's why he's being held no bond.
I understand. I'm going to do a GPS level 2 on count 1. And I do agree with the state, $5,000 bond on count 1, the trespass. Thank you. James Rozier.
He bonded, Judge.
Anthony Chinfant.
It's a medical reset, Judge.
Then we have Cleoman Paul, please.
Your name, Judge?
Okay.
You're contacting your attorney right now, sir. I know.
Yes, Joshua Fisher, please.
This is he.
Hi, Mr. Fisher. This is Judge Malika in First Appearance Magistrate Court. How are you?
Good morning, Your Honor.
If you want, it's my understanding you're feeling a little bit under the weather. Your client is being charged with, I believe it's attempted first-degree murder. Is that correct, State?
Yes, Judge. Eric Linder on behalf of...
We can continue this till tomorrow.
I can't be in tomorrow either. I have to be at the doctor.
Okay,
the problem. I don't know anything about the Hibben murder case. I know that he was picked up on a warrant. It was a pending warrant in the 2015 case that I'm aware of.
well, if you want, I can magistrate him, I can wait till you're available. Both of you agree, I mean, today's Tuesday, so we can magistrate him Thursday. We can even do it tomorrow in the afternoon, if you want to try to make it easier for you. So it will be when,
Give me 1 second, let me check my calendar. Thursday is fine.
okay, Thursday, so that'll be 3/22/18. You want it in the morning or the afternoon?
Either morning is better.
Okay, AM?
Yes, ma'am.
All right, Mr. Fisher, we'll see you this Thursday in the morning.
And Your Honor,
4155, it's on the 4th floor.
Your Honor,
Hold on, Mr. Linder is asking something, Mr. Fisher.
Eric Linder on behalf of the state. And Your Honor, just while you have Mr. Fisher on the phone, I would just ask if the court could inquire of Mr. Paul if he waives his right to have a probable cause determination within 48 hours.
Okay, your client waives his right to have a probable cause determination within 48 hours. We'll reset it for 3:22 in the AM.
That's fine. 9 o'clock?
Well, and Your Honor,
It's actually, hold on, Mr. Linder, it's at 8:30, but if you want to come at 9:30, that's fine, we're here.
Okay.
Okay? One other thing.
since you have Mr. Paul, I'm just asking if the court could inquire of Mr. Paul since we have him standing here.
Okay, what would you like to inquire upon?
If he's willing to waive his
Okay.
48 hours.
All right, Mr. Fisher, the state wants me to ask your client, or you're more than free to ask Mr. Paul if he waives his right to a probable cause hearing for 48 hours.
So you can ask with my advice to Mr. Paul, and I know you can hear me, that he waived it for 48 hours so we can be here on Thursday.
Okay, did you hear that, sir?
Yes, but I want to know what is the 48-hour waive? What is that?
Okay, that just means you're here today, sir, in magistrate court to determine if there's probable cause and bond, if any. And you have some very serious charges. So we have your attorney on the phone. He's not able to be here today, so I offered to reset it as a matter of convenience. So the only thing that I can tell you is he does need to read the paperwork. So your attorney said that on your behalf, he will waive the 48-hour probable cause hearing, and we'll just reset this till Thursday morning in the AM. That's what your attorneys has agreed to. Do you agree with what your attorney's requesting as well?
Yes, ma'am.
Okay, so you waive your right to a 48-hour probable cause hearing, and for this matter to be reset for this Thursday, March 22nd, in the AM, sir.
All right, thank you.
Okay. Thank you, sir. Thank you.
Nice lunch, everybody.
You too. You ready?
Yeah. Let me see.
Okay.